Welcome and thank you to a press conference of the Maine Choice Coalition. It's a pleasure to be here. My name is Shenna Bellows. I'm Executive Director of the ACLU of Maine, and it's a pleasure to be here today with coalition members, healthcare providers, the people whose job it is to keep women safe and ensure and protect healthcare for women. Without further ado, I'm going to start by introducing Kate Brogan, a Family Planning Association of Maine. Kate is a lawyer and works with Family Planning Association as one of Maine's 3 public abortion providers. Kate.
Hi. I am here today to talk about one of the bills that we'll be facing today, which is LD 1193, an act to allow a wrongful death cause of action for the death of an unborn child. At the Family Planning Association and the Maine Choice Coalition, we believe that all people have the right to control their reproductive lives. That includes women's right to control the decisions they make when they are pregnant. For this reason, we're very concerned about the potential effects of 1193. This bill represents a threat to the ability of pregnant women to make decisions about their lives and their pregnancies, and a threat to the availability of health care for pregnant women in Maine, including abortion services and prenatal care. LD 1193 proposes that when a wrongful act causes a loss of pregnancy, the law should recognize 2 distinct potential plaintiffs: the woman who lost the pregnancy and the fetus. This kind of recognition of a fetus's legal interest in being born is unprecedented in Maine law, and it is truly frightening for those of us who believe that women must be able to control their pregnancies. If fetuses are granted legal standing under the law, then the law must begin to weigh the comparative rights and interests of a pregnant woman and her fetus. This opens the door for unlimited interference in the privacy and freedom of pregnant women. With the outrageous proposition that a fetus is viable at 12 weeks gestation and therefore endowed with this right to sue for wrongful death, the bill exposes its true root. Viability is a key milestone for abortion regulation, both in federal case law and in Maine statute. If this bill were successful in establishing 12 weeks gestation as a legal definition of viability, ignoring all medical evidence to the contrary, it could drastically limit Maine women's ability to access abortion in the future. We believe that a pregnant woman and her fetus should never be considered as separate, independent, and even adversarial entities. LD 1193, along with the other bills considered here today, are threats to women's ability to control and make independent decisions about this most personal aspect of their lives. We stand in solidarity with the healthcare providers here today to say that government has no place interfering with these private medical decisions. Thank you.
Thank you. So Kate talked about one of the bills, LD 1193, which abortion opponents say is not about abortion. But the Maine Choice Coalition is very concerned that it does target abortion. Megan Hannan of Planned Parenthood is going to talk about the other 2 bills, LD 760 and LD 1339. Megan Hannan works at Planned Parenthood of Northern New England, one of Maine's 3 public organizations that provide access to abortion for women and other important healthcare services. Megan.
Thank you, Shenna. I am Megan Hannan, Director of Public Affairs for Planned Parenthood of Northern New England. Our volunteers, patients, and I are here today to oppose all 3 bills which would restrict women's access to health care, because we believe a woman's decision whether to choose adoption, end a pregnancy, or raise a child must be left to the woman, her family, her faith, with the counsel of her doctor and healthcare provider. My remarks here, as Shenna said, are on 2 of the bills. LD 760, an act regarding informed consent for abortion, is unnecessary and in fact harmful to the true process of consent. Every state, including Maine, requires that a patient consents before going every medical treatment, and that consent must be informed. 3 elements underlie informed consent. Patients must possess the capacity to understand what they are told in order to make the decision. They must be doing so voluntarily, and they must be provided with adequate and appropriate information. Information which would effectively coerce, manipulate, or dissuade a patient from making a different decision from one previously made, as this language intends, is actually the antithesis of consent, as it overrides the patient's access to unbiased information only. The reason we allow women to request further information is because we know there are many reasons for women to decide to end her pregnancy, and the possibility of public assistance, in this building often called welfare, or the father's support are simply not relevant. If it is, she will ask the physician and she will be sure to get accurate and appropriate answer. The sole intent of LD 760 is to shame, judge, and confuse a woman during a time she already has enough on her mind. True informed consent is about understanding accurate and appropriate information about a medical procedure, and there is no room for shame, blame, or judgment. LG 1339, the second bill, an act to strengthen the consent laws for abortions performed on minors and incapacitated persons, is also unnecessary. Maine has a very successful adult involvement law. Parents can and should be involved with their children's education about sex, sexuality, love, and relationships. In some households, that's absolutely the case. In some, it clearly is not. If a young woman finds herself pregnant and has not had a good relationship with her parents for whatever reason, once she is pregnant is not the time to start that conversation. It may, in fact, be the absolute worst time to have that conversation in some households. This bill, with its many hoops and paperwork and identity proving, is unwieldy at best, impossible for some parents at worst. Studies show only one clear result when states enact this sort of law. Young women cross the border to have their abortion in a nearby state, or they will also wait and have their abortion later in their pregnancy. Neither the pregnancy nor the abortion rates actually change because of these laws. Our adult involvement law works. In all of our health centers, the majority of young women who schedule an abortion do so either with her parents or her parents know she's going. But this isn't always the case, and it can't be. We wish it would. Our laws work, and they work well, and for that reason, we oppose all of the bills that are proposed here today. Thank you.
Ruth Lockhart runs Mabel Wadsworth Women's Health Center in Bangor, the third public site for abortion access in Maine. She's been working in women's health care for over 20 years. She's going to talk a little bit about how the process actually works when a woman comes to the center. Ruth Lockhart.
Thank you. I am Executive Director and co-founder of Mabel Wadsworth Women's Health Center, which was established in Bangor and incorporated in 1984. As we have heard, we are one of only 3 public centers where a woman seeking an abortion in Maine can go. We've been providing abortions to women in northern and eastern Maine since 1992. I'm going to share with you and the legislature and the legislative committee how abortion care works at Mabel Wadsworth Center to dispel any myths or misconceptions about how abortions are provided for women in Aroostook, Hancock, Penobscot, Piscataquis, Waldo, and Washington counties. I will also share my concerns about how the bills before us would make it harder for women to get the medical care they need. Mabel Wadsworth Center is a comprehensive women's health center offering a full range of reproductive health services, including annual exams, breast cancer and cervical cancer screenings, and pregnancy services that include prenatal and postnatal care and abortion care. We serve about 1,500 women a year in approximately 3,200 visits. Between 400 and 500 women come to us seeking abortion care each year. Most of the women who seek abortion care at Mabel Wadsworth Center are referred to us by their primary care physician, so they've already consulted a doctor before coming to us. We conduct an intake screening for every woman. If the patient is seeking an abortion, we ask detailed questions about medical history, their reasons for seeking an abortion, and their support systems. We want to be able to consult with their primary care physician if the woman is willing to let us do so, and we want to make sure that she has people in her life that she can talk to as she does make this decision. If a woman seeking an abortion is from the Bangor area, we generally make 2 appointments for her. On the first appointment, we conduct a full medical exam, including an ultrasound, to confirm how far along she is in her pregnancy. We provide abortion care in the first trimester, up to 13 weeks plus 6 days. Following the medical exam, we conduct a counseling education session for all women where we offer them information about all of their pregnancy options, continuing the pregnancy to term and parenting, making an adoption plan, or abortion. Prenatal care is available on site. If the woman decides to terminate the pregnancy, we see her for a second appointment, usually about a week later, and the abortion is performed by a fully licensed and experienced physician. For adult women from Augusta County or Washington County areas, particularly working mothers, we will sometimes schedule a single appointment where we perform first the exam, then the counseling and education session, and then the procedure for the abortion. I grew up in the county in Fort Fairfield, so I understand well the barriers to transportation posed for women for whom a medical visit in Bangor means a 6 to 8 hour round trip. We allow all women to have a support person with them through the procedure and provide a clinical assistant for additional support during and after the abortion. Most minors are accompanied by their mom or dad, but because not all minors can bring a parent, Maine's adult involvement law assures that minors always have a trusted adult present and involved in their decision. LD 1399 would eliminate Maine's adult involvement law and require that every minor obtain parental consent, seek a judicial bypass, or sign an affidavit officially naming her parents as abusers. As I shared with you, most minors who come to Mabel Wadsworth Center bring a parent. We ask every minor who approaches us to involve her parents because we genuinely think it's best for them to involve their parents in such a serious decision. The exceptions to this rule can be tragic, however. It may sound easy to the proponents of this bill to say that girls who have abusive parents or whose lives could be in danger if they tell their parents they are pregnant should just go to court. Indeed, we always urge girls who are victims of abuse or incest to go to the authorities and bring any offender to justice. But these situations are very complicated, and minors want more than anything to protect their parents, even bad parents sometimes. I came of age before Roe v. Wade. I learned then that desperate teens take desperate actions. Herbs, lie, coat hangers. I fear greatly what would happen if you pass LD 1339. Teens that can't or won't talk to their parents aren't going to start talking to their parents because the law requires them to do so. LD 760 seeks to amend the informed consent law to add scripting requirements to be read to every woman seeking an abortion. This is a medical procedure performed by trained medical professionals. Government bureaucrats should not have a say in what is said to women at the doctor's office. This is political interference in a woman's most personal, private medical decision. Doctors, not politicians, should decide what is said to a patient. And you can be assured that what the medical professionals at Mabel Wadsworth Center and our sister clinics in Augusta and Portland offer to women includes information about all of their options. It is in everyone's best interest to ensure that every woman makes the decision that is best for her and her family. And that means having access to full, scientifically and medically accurate information about abortion and about other options. Please, we are asking the legislature to not force our doctors to read a script that injects non-medical information designed to shame the women we serve. We started Mabel Wadsworth Center because we believe strongly in providing the best possible health care to all women. We also wanted to be independent of government funding, and we wanted women to be safe. Our center is picketed every week by individuals who are against women making their own personal choices about their health care. The doors at our clinic are always locked. No one can come in without a prearranged appointment, and our windows are bulletproof glass. As I said before, women are coming for a wide variety of services. Most of our patients are mothers. Many of the women who seek abortion care in our clinics are mothers too. We're asking the legislature to not place more unnecessary political barriers between these women and their access to a safe, legal medical procedure. Thank you.
Thank you. And I know that TV has to go, so we'll just pause for a second before we hear from a doctor, family practitioner who also has provided abortions in rural Maine, and also from a nurse midwife.